Hello everybody, welcome to the WIPF Virtual Conference 2021. I'm Peter Staud and I'd like to talk about filling a gap and coming to aid to strengthen patent protection in Germany. And before we go into details, let me reduce this so you can better see that. What we are talking about is a German utility model which can come to aid just where needed and not instead of patent protection, but in addition to it. A patent, as we all know, provides protection for technical inventions for up to 20 years. And in almost all jurisdictions, it includes substantive examination concerning particularly novelty and inventive step. And so it provides a certain certainty concerning validity and a certainty which is obtained in a quite cost-effective way as compared with private searches and private opinions. But still there are some gaps. What and where are these gaps? The first major gap is that there is no injunction based on late open patent applications. The application is filed and published after 18 months. And during that time, there is some protection against use by others due to secrecy. But then it's laid open. And until finally granted, and there will be protection of use by others due to claim to injunction after grant, during this time of X years, which can be several years, 2, 3 to 15 or more, there is no protection against use by others. Another gap or uncertainty can be found concerning the prior art, which is found during prosecution. Certain prior art will never be found. The patent offices conduct the examination based on what they have in their files, which is written prior art or the databases, and which does not include usually any oral publication or any public prior use. However, if after grant in opposition proceedings or immunization proceedings, an opponent submits further prior art in addition to written prior art, namely some evidence concerning oral publication or public prior use, this can lead to revocation of the patent. And the third thing is that there may be a pre-disclosure by the applicant. And as we know, there is no novelty grace period for German and European patents. So what can be the solution? It is a German utility model. And to make that clear right at that point, this is not about a patent or a utility model, but it's about a patent and a utility model or a patent application and a utility model. In all these cases, the prosecution starts with a patent application. And then a utility model is added when we need it, which can be during prosecution of the patent application or immediately after grant of the patent or immediately after rejection of the patent application. Before looking into these instances, let's first look at a German utility model. What it is. It provides protection for technical invention, and that means for all patentable subject matter except for methods and biotech inventions. The term of protection is 10 years, and there is no substantive examination concerning particularly novelty and inventive step. So a utility model alone will provide uncertainty concerning validity, but it has a speedy registration procedure because there is no examination proceedings, and that means it's registered usually in about 3 months. Its life story is that we apply for it, the German utility model, and after filing the application, there's no publication of the application, so we still have protection against use by others due to secrecy. And after 2 or 3 months, we have registration, the registration is published, and then we have protection against use by others due to claim to injunction, as long as it expires. If we compare these two, we find that utility model has a lower requirement for inventive step as compared with a patent. And this is shown in the wording. The Utility Model Act says, literally translated, that an inventive step is required. For a patent, it says inventive activity. So this indicates somewhat lower for a utility model as compared with a patent. And then we have less relevant prior art for a utility model as compared with a patent. And we have a 6-month novelty grace period, while we have no grace period for a patent. As to this relevant prior art, for a patent, everything is relevant. Everything disclosed prior to the time rank, which is the filing date or the priority date. That means all written disclosure worldwide, all oral publication worldwide, and all public prior use worldwide. For a German utility model, it's all written disclosure worldwide, but as far as oral publication or public prior use is concerned, only if it's done in Germany. So we have looked at the different terms of protection, 10 years versus 20 years, but then the average duration of a patent is 13 years in Germany, so it's not that much a difference. And both IP rights convey identical protection, namely claim for injunction, claim for damages, claim for disclosure of information concerning infringing activities, and claim for destruction of infringing products. And the scope of protection is determined in both cases by the content of the claims. So if we have identical claims, we have identical protection. Going back to see the utility model versus the patent, we remember that the utility model has uncertainty concerning validity, and the patent has some certainty because it has been examined. So the combination of both provides the advantage. And this advantage can be used only when we need it. And it can be done by a so-called derivation of a utility model from a patent application. That means just when needed, we derive a utility model. We don't have to file up front. This derivation of a utility model can be done from any patent application which is effective for Germany. So national German patent application, a European patent application, or a PCT application, if Germany is designated for the two-letter. It can be done up to expiry of a period of 2 months from the end of the month in which the patent application is disposed, which means rejected, withdrawn, or deemed withdrawn, or the patent granted, or, if applicable, opposition proceedings are terminated. We'll look into that later. First, let's see how we derive a utility model. We need application papers corresponding to the patent application. If the patent application has number in German, we need a German translation. And we can effect amendments like deleting method claims or doing some revision in view of prior art located by search report or exertion report concerning the patent application. In all of these cases, the prosecution starts with the patent application, and a utility model is added either during prosecution of the patent application or immediately after grant of the patent or immediately after rejection of the patent application. And we look at these 3 instances now in more detail. The first one is that a utility model is added during prosecution of the patent application. In that case, the patent application is further prosecuted and the utility model provides protection after publication of the patent application. That means the patent application is pending, it has been published, and as we have seen, there is no protection against use by others. Now let's assume that the applicant becomes aware that a competitor is using the invention and distributes products. In that case, we can derive a German utility model. It will be registered after 3 months, and then the applicant has protection against use by others. The second case is the utility model is added immediately after grant of the patent. In such case, the patent remains in force, and the utility model provides additional protection because it is more difficult to invalidate by the patent. When a granted patent is found novel and inventive, this is based on written prior art which had been available at the patent office. Now, an opponent in opposition proceedings or invalidation proceedings may rely additionally on oral disclosure worldwide or public prior use worldwide. Now, in case there is non-pertinent, non-written prior art coming from outside Germany, a patent would be revoked, but a utility model would still be valid. As far as obviousness is concerned, there may be no inventive activity which is needed for a patent, so it would be revoked. But it still can be inventive because there's an inventive step according to the utility model which would still be valid. And it may turn out that the applicant has maybe unintentionally published the invention prior to the filing date, prior to the priority date. In such case, because there is no grace period for a patent, it would be revoked. But for a utility model, there is a 6-month novelty grace period. So this means even a granted patent can be strengthened by a parallel utility model. And to give a typical timeline, application in German, the patent application is filed, there's a decision to grant, and it becomes legally effective, and then we have a first deadline for deriving a utility model. And the publication is granted, and the publication of the grant is effected, and an opposition is filed. And let's assume this opposition leads to revocation of the patent. And this revocation becomes legally effective, and then we have a second deadline for deriving a utility model. So we can use this twice. And this second derivation relates to a situation where the patent is not existent anymore. And so it is similar to our third instance, namely when a utility model is added immediately after rejection of the patent application, or as I said, revocation of a patent. In that time, the utility model provides possible protection because of less stringent requirements. And we had talked of these requirements, namely the less restrictions due to obviousness. And so that means that a derived utility model may still be valid because this level of inventiveness can be lower than the inventive step for a patent. And also, as we have said, the issue of publication by the applicant can be decisive because we have the 6-month grace period for a utility model, nothing like that for a patent. So, in summary, this derivation of a utility model from a pending patent application or a granted patent can help fill in gaps and can strengthen protection. In the last case, we have this date of rejection, becomes legally effective, and we can have a deadline for derivation of a utility model, and we can still have that, which remains a threat to the competitors. So I thank you for your attention, and obviously this was a lot of information in very limited time. So if anybody has any questions about it, please feel free to contact me. Thank you again, and bye-bye.